Good afternoon, everybody. I'm Deborah Vitzi. I'm the President of the Family Law Practitioners Association. I'd like to welcome everyone here this afternoon. We've got three very interesting speakers going outside the normal bounds of family law, but the Family Law Practitioners Association thought it was important that we learn about other areas that may impact on our practice as family lawyers. So without any further ado, I'd like to introduce the first speaker, and that is Cameron Graham. Cameron joined Barry Nilsson Lawyers as a partner in 2007 after having practiced as a solicitor in New South Wales for 2 years and Queensland for 12 years. Cameron has considerable experience negotiating purchase, sale and leasing transactions for retail and commercial properties. Cameron is a regular presenter of seminars regarding a variety of property-related matters for the Property Council of Australia, LexisNexis, LegalWise, Television Education Network and the Queensland Law Society. So could you please join in welcoming Cameron.
Get my Dutch courage and move on. Can you hear me?
No.
Okay. Is that better? Okay. Good afternoon or good evening. Thank you for the introduction. Yeah, so my background is property law, so I'm going to try and give you a brief snapshot of the new Personal Property Securities Act and ideally how it will impact upon your practice as family lawyers. Today I've only got 20 minutes, so I'm going to be relatively broad brush and just give you some pointers. They're the things I'm going to touch on today, so some introductory points, registration, some practical examples, types of searches that you can undertake, and also how you can get those security interests released. So just firstly, in terms of some introductory points, PPSA is concerned with personal property. So forget about land, forget about fixtures attached to land, only personal property. Okay, now personal property is obviously household chattels. It also includes shows in action, includes shares, and intellectual property management as well, and obviously motor vehicles, boats, and things you can take away. So, and personal property in that legislation is described as being collateral. So unfortunately we need to get around some new jargon, so it's now called collateral. So whenever you're talking about property which is subject to security, the definition of the secured property is always collateral. Okay? In terms of types of security, so things like fixed and floating charges, bills of sale, motor vehicle securities and retention of title arrangements. And now this, for the purpose of the Act, referred to as being security interests. And in terms of what's happened to the previous registers, things like revs and your ASIC charges have now been migrated with effect from the 30th of January onto what's called the Personal Properties Securities Register. So when you do a company search, you will no longer see reference to the charges on the company. They're all now on the PPSR. So you need to do a separate search to determine what charges are registered for the company, which can be a bit of a nuisance, but that's the way, that's the new regime. So in terms of registration, if you have collateral and you have a security interest in that collateral, whether it be the retention of title, for example, when a supplier supplies something to someone else and retains title until they're paid, or whether it's a chattel mortgage or a case of motor vehicle that might be just a financing interest, you must register your interest on the PPSR to defect that interest. If you don't, then the consequences can be quite dire. Because if you're not in possession of the collateral, then the person who is in possession can sell it and pass a good title to the buyer. But that's thinking for a while. So that rule that you may have studied in law about NIMO DAT no longer applies in this context. You can pass a better title than what you currently have. I mean, it's probably fraudulent, but leave that aside, the buyer of the property, if there's nothing registered on the PPSR, they can take a title clear of any unregistered interest. To give you a good example of that, a New Zealand case, New Zealand have had the equivalent of the PPSA for some years, as has Canada. And for those of you who are interested in horse racing, there's a particular situation where a stud farm leased a very valuable stallion for the purposes of I suppose, breeding, and the owner of the horse did not register the interest that they had, the leasehold. In fact, they were the owner, and there was a lease of the horse. Unfortunately, the stud farm went broke. Perhaps the stallion wasn't as good as it could have been, but so the liquidator moved in and sold that stallion free of the interest of the owner. And whilst the owner ran off to the High Court in New Zealand, ultimately lost. So you can, in that situation, the liquidator can pass a good title to a buyer, even though the party in liquidation didn't have title, didn't have an adequate title. So that's just something to be aware of. That possession, there used to be a phrase that possession is 9/10 of the law. Well, in this context, it's now 10/10. Okay? So just be aware that if any situation where there's a retention of title or ownership and you're out of possession, you need to make sure your clients register their interest. Okay? Just to give you some practical examples, I've tried to clear up some things about what might happen in a property settlement you might be involved with. So let's say, for example, that you're acting for the wife, and as part of the property settlement, it's agreed that the wife's going to take unencumbered title to a specific motor vehicle. Now the phrase, the crucial point there is unencumbered title. Okay, in that situation, you normally would carry out a rev search, and you would have found that okay, there's financial. Well, now you'll carry out a PPSR search of the motor vehicle. You'll see there's a registered security interest, and you'll make sure that's paid out before the vehicle is transferred to you. So that's a fairly simple example, but it's a different search that we're going to be conducting. Another example in this case is for the husband, and the deal is that the wife is going to transfer, free from encumbrance, a portfolio of shares held in various ASX listed companies. In this situation again, you're going to have to do a PPSR search because there could be some margin lending in relation to those shares. So again, you need to make sure you get a clear title. So you'll turn up the search and turn up the margin lending arrangement to make sure it's paid out beforehand. Obviously, if there is no registered interest, for example, because the margin lender hadn't registered their interest, the wife will take a title clear of that margin lender. Obviously, the husband will probably still have a debt, but there'll be no asset to secure the debt. Okay, so another situation to be aware of. Another one which came across my desk recently was actually referred to me by some colleagues in our family law group. In this situation, was proposed, although the dollar figure is different, the wife was going to take a security interest over the husband's company to secure payment of a sum of money to the wife sometime down the track. And in that situation, a PPSR search of the husband's company disclosed that NAB had a security interest over all present and after acquired property. Now, before 30 January, you'd have called that a fixed and floating charge. Now it's just called a security interest, and the terminology is all present and after acquired property. And so you said, well, look, chances of getting a release from NAB are pretty slim because it's all tied up with the whole financing of the business. So at best, you're probably going to get a second ranking security interest. And in that situation, I recommend that you approach NAB with a view to negotiating a priority deed so that you can limit NAB's priority to a certain figure. That way, at least, in theory, there might be something left for the second security interest, which is in this case your client. Any questions before I move on?
When you search the PPSR, are you searching by a personal name or are you looking for an identifiable asset?
That's my next slide. Thank you. Okay, so types of searches. You can search under a serial number. For example, for a motor vehicle, you'll search under the vehicle identification number or VIN. And For older vehicles, you can also search under the chassis number. Boats, you can search under registration numbers, aircrafts, intellectual property, for example, registered designs and trademarks, you can search under the relevant registered number. Now, if that shows up nothing, that's not necessarily the end of the story. Because if you're taking property from a person, you should also search that person. Now, you can search on an individual, you can search on a corporation, or you can search on some other organisation which has a separate legal entity, or sort of like a corporate personality. So there are a range of ways you can search, and you can also search under the actual PPSR registration number. That would be very rare that you know that, but if for example, you do know the number, then you can actually get a copy of the relevant documents there. So there has been a little bit of criticism. Unfortunately, the migration of the ASIC records over to the PPSR wasn't quite as smooth as one would have liked, and so consequently, if you're searching on a corporation, my recommendation is that you also search the ACN, you search the ABN, and you search the name. And I have had a clerk do that, and in 2 cases she got nothing, in the 3rd case she got something. So just be aware. Unfortunately, that means 3 lots of searches, 3 lots of search fees, but if you're acting in a situation, it's pretty well known what might be publicised that there are problems, so you need to make sure that you do thorough searching. Happily, the searches aren't particularly expensive, but I recommend that you use a bit of caution and search for whatever parameters you can to make sure that you capture all the possible security interests which are registered. Okay, this last slide I'd like to talk about is releasing security interests. So before the PPSA, if you were attending a settlement, someone would come along with a Form 312. Here's my release of the charge, if it's a company. Well, that's no longer the case. So now it's actually a bit of a vacuum. So the Australian Banking Association realised this pretty early on, and they prepared a pro forma document which they're calling a release and undertaking to amend registration. So the release is typically drafted like a deed poll in favour of saying we release this particular charge or this particular security interest. But in addition to releasing the security interest, there's also another step, which is to actually register the release on the PPSR. That's something that you should make sure happens, because and typically that's not going to be done before you settle a transaction. So that particular document contemplates that the registration takes place within 5 or 10 working days after the document is signed. So not a perfect situation, and so you won't get your Form 312, but hopefully you will get something. But you need to contact the security interest holders well in advance to make sure you have that documentation available, so that your client retains an unencumbered title, which is really what you do. And if you're not getting that, then you shouldn't really be involved in these transactions. It's obviously, it's one thing to do litigation in the family law, but at the end of the day, property settlement is often what a lot of clients are more focused on. So that's all I have to say. If there's any questions, please fire away. Sure.
Hi, just with the documentation that's produced, so if you do register an interest, just from family lawyer's perspective, when we're seeking disclosure of documents, are there particular documents that we could request which would show that there is an interest? Is there like a registration confirmation?
Well, look, I mean, if I was acting in a family law matter for a wife, I'd do a PPSR search not only on my client, but also on the husband, to try and work out are there any secured interests. Because obviously in the context of disclosing assets, it's material to know what security there is as well. Now obviously, I mean, in most cases, the respective parties would have some idea of who the financiers are, but in some cases that's not the case, and so we need to do those searches. But yeah, those searches will then show there's a security interest, and then you can then drill down and get copies of the relevant documentation which have been lodged. Now, in many cases, that won't give you enough information. Because it might disclose that there used to be a fixed and floating charge over the company, which is now a registered security interest, but it won't tell you how much is owed. But it does put you on a trade inquiry that you can then subpoena the bank records and get copies of the relevant information. But so I suppose that's, it's not, won't give you the whole story, but it will put you along a trade inquiry to then find the rest of the story.
If you had, say, for example, a stereotype of a trading partnership for a husband and wife, a plumbing partnership or a building partnership, the husband owns the work vehicle and the wife often has the sedan, which is owned through the business, but the wife is taking this as part of the property settlement. How do you remove the and that is financed to the bank?
Sure.
How do you remove the charge of
Security interest.
over that vehicle under those circumstances?
Well, obviously, the financier has a security interest, they must be paid out in some way, so they'll then release the security interest and your client then takes no income title. Now, how you do that is a really matter for negotiation in terms of where the money's coming from to pay out that security interest. It may be that it's an unsolvable question because there's not enough cash to pay out this.
So would you just word your order more or less the same way you do when you're releasing a mortgage, something effective that the parties will do all that's necessary to sign the necessary documents with the XYZ bank to release the PPSR interest over the money
to release
XYZ.
any security interest,
Yes.
any registered security interest over the relevant motor vehicle. That's right. But yeah, look, it's the PPSR will flag in one place where the security interests are, it won't necessarily solve the problem of actually getting them off the relevant passing and uncoming time. And that's, I suppose, a matter for negotiation in terms of how you can arrive at an uncoming time.
Just flowing on from that a little bit, if within the confines of property settlement, a security interest is actually paid out with a financier, do they then register the withdrawal of PPSR, or is that something that we need to take care of?
It's a matter of discussing it with the relevant financier who's going to take responsibility for doing that. But certainly, as a solicitor, let's say if I was acting for the husband and it was the husband's financier who was being paid out, then I would want to make sure that security that withdrawal is actually lodged, so that the husband no longer has that security against his name. But yeah, look, it's a matter of how the documentation is drafted, and certainly that document I mentioned, which was prepared by the Australian Bankers Association, contemplates that the financier will lodge the withdrawal within a certain time. However, it's not, and typically the reason is that on the PPSR website there is provision for it to be done electronically, and to do it electronically you need a particular login ID and a password which only the financier has. And so that's, I imagine what they'll be doing is basically assigning someone to do that on a daily, weekly basis, and they just basically dump all the information on once and press send, and on mass a huge number of security numbers.
With the problems they had in migrating the securities over from ASIC, was it just when the ASIC registered that they had problems with? Because I'm concerned that our exposure as solicitors for missing charges that haven't been carried across on the register.
Yeah, I am too. And there are, I think if you went to the Lexon website, over the QLS website, I'm pretty sure they've got some summaries of the problems, and there are some lists. I think there's a list, one of them has like 6,000 companies or charges on there which we're the problem with. So I recommend that you look at those websites and access that information as well, just to clarify whether the security interest you're looking for may fall within that particular category. So there are, I mean, I haven't had a cause to look at it recently, but they're working through it, hopefully in a year or so they'll have sold all the problems, but a lot of the financiers, there's a particular category where they didn't migrate at all, and they're issuing what's called a verification statement. And so you may hear of a client or someone you know receiving a verification statement in the mail, which is basically saying, can you verify that this charge is fair income? And if you don't do anything in a certain time frame, then there's consequences which flow. So if you hear of someone getting a verification statement, I recommend they do act upon it rather than just ignore it.
Seems like as a solicitor, then, if I'm drafting a property agreement for whatever side it is, then there may be a duty on me to, when we're dividing up personal property, do a search here and satisfy.
That's right. Yeah, I think there is. I mean, certainly Lexon's put out alerts about it, and certainly in terms of all the documentation that they've used in the past, you need to really look at that closely and think, is that wording still appropriate for this new regime? And any references to charges, throw them away. And just use a generic term like a security interest or a general security interest. So your pro forma orders, which they've used for many, many years, you need to look at those critically and make sure they still cover a particular situation. So one of my jobs was to redraft a particular clause that my colleagues have been using to fit this. And it's not particularly difficult, but you just need to have a bit of an understanding of the terminology that the PPSA uses, so that it can be sufficiently clear what the parties' obligations now are. More questions?
Thank you very much, Cameron. That was very informative. Okay, I'll move on to our next topic tonight, and that's in respect of the conveyancing protocol and how that is going to impact on our practice as family lawyers. So our next presenter is Scott Jenkinson. He is a director of Warlow Scott Lawyers. Scott was admitted to practice in 1991. He established his own firm in 1999, trading as Scott's Lawyers prior to joining forces with John Warlow in 2002 to provide wide-ranging property and commercial legal services as Warlow Scott Lawyers. So if you'll join me in welcoming Scott.
Good evening, everyone. I apologise for PowerPoints. What I hope to do tonight is hopefully give you an overview of the protocol for family lawyers, not in a way that I give you the nitty-gritty and the detail. I don't think that's what you need. That's all up on the Lexon website. What I wanted to do is give you a general overview of it, understand why we have it and when it comes into play. The particular relevance for family lawyers may not apply across the board. However, hopefully at the end of this evening, you'll get an idea of where it will affect your practice. Some of you will be sole practitioners, others of you will have much greater resources where you can tap into specialised property advice, and that will be less of a burden. However, at least you will know what the alarm bells are and when it will come into effect. The main alarm bell is that the conveyancing protocol is designed for all our insurance premiums to be lower. The main way they've done that is to provide a deterrent excess of $30,000. So if you make a claim through Lexon for professional negligence in the conveyance of a property, they're going to hit you up for the standard excess of $15,000 plus an extra $30,000, meaning $45,000. So for us in the property game, where we are set up for property transactions and we do hundreds every month, it's been a burden for us. The way we've complied with it is systems and adherence to good management and good documentation. Now, the days where you could just do a conveyance and have a low-level conveyancer just go through the motions, do a few searches, and then attend settlement and finish the file, that's gone for us, because we as a firm make the decision that that $45,000, which we've never gone near, will be too much of a burden. You have to do a lot of conveyances to get $45,000 back. So that's the alarm bell number one. So protocol itself is, it's just a general guide, but it's a large general guide. It's about a lever arch thick, and it covers most property transactions that most of us will come across in Queensland. It doesn't specifically address the family law transactions where you get, say, consent orders, but I'll address that throughout my talk tonight. It does have a number of different documents. It has buyers, questions for the buyer and seller. It has checklists. It also has purchaser inquiries, and it used to have tips for, a checklist, but that checklist was 31 pages long. So they've now changed the checklist to how to do the conveyance, and that's about 30 pages long. Now, it's, the protocols are done by Bill Duncan and Sharon Christensen, and there's nothing in there that you wouldn't expect a very cautious conveyancer to consider doing conveyance. There's a lot of things in there that you might expect an experienced practitioner who's been doing conveyancing for many, many years to go, I've never done that. So it's a real battle. Do you comply with every little dotting of I's and crossing of T's in that conveyancing protocol to risk that $45,000? Because we're all human, and the other thing I can recommend tonight, if you get a chance, Lexon do have a great service where they send an experienced ex-practitioner around, generally in your area of expertise, and they'll go through and they'll tell you about the latest claims. They'll tell you where you're at most at risk. And to their credit, they're very sympathetic, particularly in relation to how hard it is to practice law and the demands on a day-to-day basis. So it's not all bad news, but to avoid that $45,000, you've got to step up quite a bit from what you're used to. Now, that moves into why we have it. It really came about because when the cut price conveyancing came right down, everyone went, well, I'm getting paid. When it was scale, it was pretty good rates, and then it became not very good rates. So the standard slipped. If we're not getting paid as much, we're not going to put as much effort into that conveyance. I can assure you that the conveyancing protocol requires you to put 100% effort into it. There's nothing that is easygoing about it. It's not. You can't say that it's over the top, but it's hard in every respect. You have to keep complying on many levels. So what you have to realise is that it's there to make our insurance premiums lower, and that has happened. So a byproduct of everyone being scared about the $45,000 is they've actually had to read the protocol. And if you had never done a conveyance before, or if you're a family practitioner just thrown a file and say, do these transfers, we've got the sealed orders, then that would be a good place to start to learn if you knew nothing else. So it is quite helpful, and a lot of practitioners use them as a checklist. It's a lifesaver for some practitioners. Who needs to abide by the protocol? I struggle with this because when we think of a conveyance, we think of a mum and dad buying a house and investment or to live in, and there's some money changing hands. But in your scenario, your mum and dad fighting over the house, the farm, the commercial property, the shares in that unit, in that company which owns that, and the units in that unit trust which owns that other property. So you actually get your liability brought forward. Now, because once you've got your consent orders, that's just an order of the court, and you have to comply with that, and that's just a mechanical process. However, if we wind time back a month before you've got those sealed orders, you've got the wife saying, I just want that shop at Lutwich. I want that, and that's got a nice tenant in that, and that will do me for the rest of my life, and I'm not going to pursue these other claims. I'll accept a lower distribution of the other property, but I want that shop. So you could say, well, I'm a great family lawyer because I got the shop. So that's a case study I'll run through later on. Now, one of the things you'll find when you go through the protocol is the best thing you can do to comply is to get the terms of your retainer straight at the front end. Now, as part of the protocol, Lexon produced a very detailed and lengthy set of first letters. Now, those first letters you do not have to use strictly. Our firm has made a decision that we will adopt comparable letters, but they are very stern, and the letters basically say, instead of saying, we're here to serve you, we're here to get you a good result, and we're going to do a good job, the letters say, we don't do this, we're not advising you on that, and our retainer is limited strictly to this. So, if you want to avoid the $45,000, you have to toe that line, somewhere or another. You have to be very strict with your retainer, otherwise you're going to be heaped with all the obligations of a general advisor, and who's definitely should be advising their clients in relation to the properties that are being transferred. So your options then, as a family law practitioner, when you've got mum chasing the property at the shop at Lutwich, you can either comply with the protocol, and a lot of it won't apply to you. There's PAMDA, property agents and motor dealers disclosures, there won't be any of that. You can skip through a lot of those 30 pages. You can also refer the work out, or in a lot of cases, you can simply contract out of it. You can say, we are not advising on this. If you would like advice in relation to this particular property, we're not giving it. We recommend you seek independent advice on it. Everyone will have a different setup within the way they operate, whether they're sole practitioners or they've got 20 other lawyers in the firm. That's a decision for you to make. We found the conveyancing protocol very onerous at first, but in the end you just accept it. But we have the same contracts coming in, day out. You, I suspect, can have very complicated transactions with particularly isolated facts in each case. But unfortunately, that's what the protocol lumbers you with. Now, the good news is that you will not have to pay the $45,000 if you show bona fide endeavours to try and comply with the protocol. Now, if you speak with the Lexon people, they're quite tolerant about it. But if you have a file that doesn't have anything of the protocol, nothing to do with limited retainers, no consideration of searches, no advice of the client, well then that lack of paperwork is going to be your downfall. The way you get through it is by having the systems and having the paperwork and at least attempting. So I don't think you can get away with saying, look, let's get a valuation on this and then we'll transfer it and we'll make sure there's no mortgage on it. That wouldn't satisfy the protocol for the reasons I'll go through in a second. To comply with the protocol, you would define your retainer. The best way to do that is on the first letter. Now, our first letters were comprehensive, we thought. Now, they would be 4 times the size. We have a booklet, and it confuses the buyers. There's less understanding than we would like, but the protocol is not about informing the buyers, it's about reducing our risk. Unfortunately, that's the view we've had to take. And
that can be softened by your first phone call, and which we all endeavour to do the best by our clients, but that letter should go out. So I would recommend that at the very least, that if you're not set up for conveyancing, is that you develop your own precedent letter to send out for a transaction for each property transfer. And if I was you, the first place I would start was on the Lexon website and click on their first letters package. Second part is ascertain whether it's residential or commercial, buyer or seller, house name, community title. That just determines which protocol you're going to use, and then you print that out and go from there. There's questions for the buyer. Thankfully, that's only about one page. You should use the appropriate letters. If you don't have the time to adjust yours, then you'll find theirs are pretty brutal, but it's better than nothing. The next thing is run through appropriate searches. Now, after I've just finished the case study, I'll go through quickly, read out some of the searches that they require you to consider. Now, there are a lot of them, and for the normal suburban house, they're not going to be relevant. But I think the greater crime for you is not to do the searches. The greater crime is to not have that piece of paper on your file to say, I have gone through the searches with the client. Because most of them aren't going to need a heritage search. Most of them aren't going to do a railway search if it's $40 and it's not near a railway line. But for you, having that piece of paper on the file will be the best thing you can do on the protocol. And last of all, bona fide endeavour. As I say, my experience with insurers is they're fairly strict when they're interpreting their whole policy. And if you make a $100,000 mistake, they'll ask you to chip in the first $45,000 and they'll pay the next $55,000, because their $55,000 sounds a lot better than $85,000. So I'm unaware of when Lexon, any instances or examples where they've imposed the deterrent excess, but if your insurance premiums keep going up, they're probably